their basic rights. So I'm going to go through it. Look, clickers decided not to work. We go. How do I get back now? Hang on. There we go. Who am I? My name is Rosa, and I've worked in this space for over 25 years. I've been an ER person, an HR person, then I trained as a lawyer. And I've worked as a dedicated employment lawyer now for over 10 years, both in-house, for top-tier national firms, for organisations big and small, corporates, government departments, etc. Employment law is all I've ever done and all I've ever wanted to do, so it's my passion. What I wanted to talk about today in a really foundational way was to look at where employment law comes from. So this is what this diagram is about, and I'll talk about each of these aspects of employment law. Underpinning everything is the Fair Work Act. It gives you, I've got that one next to, so it gives you your base entitlements. You would have heard of national employment standards possibly. It gives you your base entitlements. Sitting on top of that are modern awards and enterprise agreements. They give you a little bit more than your base entitlements or different things to your base entitlements. And sitting on top of that is employment contracts and policies. They all swim, that's why I've tried to do a lake, in a sea of common law. And common law is like judge-made law. That's when you take a matter to court and a decision is made. So decision was made last week that had a lot of impact on people, or will have, is that casuals might be able to access entitlements like annual leave and sick pay. So again, that's very interesting. Hello, I've got someone else coming. There's another one coming. Hello, look, you haven't missed much. I've just said introduce myself, and we're looking at employment law and where it comes from. So what I've said is that there is a base of the Fair Work Act, and on top of that sit awards and agreement, and on top of that sit employment contracts and policies. And they swim in an ocean of common law, which is where decisions are made in courts. So you would have heard recently, you may have heard that casuals might be entitled to annual leave and sick pay now. And that's a new decision that's come out just last week, which is really controversial and really difficult for employers. But the other thing that happens is that there's other legislation. I don't know why my clicker's a bit dreary. So you've got the Fair Work Act, and other legislation you would have heard about is things like the Disability Discrimination Act, the Long Service Leave Act, the Equal Opportunity Act, and Occupational Health and Safety Act. And what I've tried to show there is how they all impact and sit and affect your employment and your employment relationship. So, as I've tried to say, it's a pyramid of entitlements. Now, if anyone's got any questions at any stage, put your hand up or even interrupt. I think I can have a little thing down the side to say if there's a chat, if anyone's got any questions they want me to answer. So there's a Fair Work Act, which is minimum baseline entitlements. Modern awards are industry-wide agreements. So, for example, you might have like hairdressing agreements. So it covers all of the hairdressers, regardless of which employer they work for. Alternatively, you have enterprise agreement. And what that enterprise agreement does is covers everyone in the enterprise, regardless of what job they do in the enterprise. So you can see they've got a different focus. Then on top of that sit employment agreements. They're specific agreements. Will cover things like, you know, you might get a laptop with the job, you might get a phone, and what's to happen with that, and what's to happen if you've got to return your material when you leave, and what happens if you have access to confidential information, etc. Okay, and then aligned with that or sitting with that are policies, and they're more behavioural guides. Like you'd have heard of a code of conduct at the workplace, things like anti-bullying policies. They're behavioural guides in the workplace. So you can see why I've done it as a bit of a pyramid, because there's the base, and then on top of that is all these other sorts of agreements. Here you go. There's also, which you guys would be familiar with, can't see people. It makes it easier for me if I can see people I'm talking to. People might want to turn their video on and their audio if they want to talk to me, so feel free. You would all know that there's different sorts of employment relationships. There's casual, there's fixed term, Casual is where, a true casual is where you are called on an ad hoc basis, although I think it's misused a lot and people have casuals employed for years, and that's where you get into trouble. You have fixed term, where you are again engaged for a particular period of time. Then you have permanent ongoing employment. That can either be full-time or part-time, but I've got full-time there. And you can have people who are contracted, so their own businesses and who contract to you. So there's all different sorts of arrangements and they all have different complexities. Hello, Sarah, I can see you now. My clicker doesn't really want to click, which is really annoying. And neither does mine. Here we go. I want to talk now a little bit about some of the bodies that you would have heard of and you would have come across. The Fair Work Ombudsman, that is a statutory authority. So it's a semi-government authority that was established by the Fair Work Act itself. And it monitors, investigates and enforces compliance of Australia's workplace laws. You can make complaints there if you're being underpaid. You can check your award coverage. It's an amazing thing we have in Australia. And you would have heard that it investigates and fines people, fines employers when they're underpaying. Like there was one last week, I think it was $800,000 they got fined in total for underpaying. It was like a sushi cafe, a chain of sushi cafes. They have broad powers. Broad powers is a really legal way of saying they can pretty much do what they like. You've got a very powerful organisation. I'm going to keep persisting with my clicker. There we go. We've got the Fair Work Commission. It was also established under the Fair Work Act. And it's got lots of functions, big functions as well. It's got a new function that started recently. And again, you would have heard of this, that it's got a new JobKeeper function to monitor and hear disputes over JobKeeper. It handles unfair dismissal, anti-bullying, adverse actions and unlawful termination. So if you get sacked or if you get bullied or if you, I suppose, get sacked and bullied, or if you have disputes with your employer, that's where you go. It also sets the minimum wage. You would have heard that every year there's a minimum wage decision. It sets the minimum wage. It makes reviews and varies modern awards. It assists with bargaining for enterprise agreements. So if the employer is trying to bargain with his employees, it can assist with that process. And it approves, varies and terminates enterprise agreements. It can make orders to stop or suspend industrial action if someone's on strike. And it deals with disputes brought under the dispute resolution procedures of modern awards and enterprise agreements. If you look at your award or agreement, most of them, if not all of them, have a dispute resolution section. The first point of call is to try and resolve your dispute with your employer, but if you can't, there's an escalation. Ultimately go to the Fair Work Commission for firstly conciliation, then a hearing, and then finally like arbitration. So again, it can resolve your disputes in the workplace. Let's talk about stand down. Has anyone been stood down? No? Well, let's talk about stand down. It's interesting because stand down wasn't something we heard much of before COVID-19, but employers have always had the opportunity to stand people down. Not the opportunity, it sounds terrible, the option just to stand people down if they couldn't work. So the usual, hi Amy, I can see you now. The usual thing for standing people down was where they, like maybe they were window washers or window cleaners, and it was raining, so they can't work, so they stand them down. So those sorts of industries used to have it contained, or would often have it contained in their award or their enterprise agreement. Places like banks wouldn't have had it because there's very, very few circumstances where the employees can't work, except when COVID-19 happened. So it made everything, it just turned everything upside down. So if it's not in the employment contract or in your modern award, and that's what happened very early on in the days of the COVID, everyone relied on the Fair Work Act, because the Fair Work Act, section 55241, always had a stand down provision. It had a provision that said a stoppage of work for any cause for which the employer cannot be held reasonably responsible. There was a lot of argy-bargy up front. Are you writing a question, Sarah? I can't see your questions. I can't see them just yet. If there was any stoppage of work for, and there was a lot of argy-bargy early on. Qantas stood people down. There was a question whether they could, but it then became linked to, if you had a government directive, like the hairdressers and beauty salons couldn't operate, so they could stand their people down. But you couldn't stand people down just because your business had slowed down a bit. And that happened a lot, and that caused a lot of unfair dismissals. I won't go into that. So what causes a stoppage of work? So as I said, you're either directed by the government to close your doors, or someone who's key to your supply chain has been directed to close its doors. So you can't get essential components. So that's another way. So, but really importantly, a downturn in your business is not grounds for stand down. An employee could be subject to unfair dismissal claims. And during a stand down, an employee can work for somewhere else with employer's permission. I'll go into this a little bit more detail later. But really importantly, if you have been stood down, it doesn't break your continuity of service, and you continue to accrue entitlements based on your normal hours of work. That means long service leave, annual leave, sick leave, etc. Let's talk about unfair dismissal. I don't know if anyone's ever had much experience with unfair dismissal, but people have to dismiss someone, you must have a valid reason related to conduct or performance, and it can't be harsh, unjust, or unreasonable. Not like Donald Trump. When might it be harsh, and when might a dismissal be harsh, unjust, or unreasonable? Well, these are some examples from the Commission. Did you know the reason for your dismissal? Did you have a chance to respond to the reason? Was your employee permitted to bring a support person? You've got to, if you ask for a support person at a meeting, they can't refuse you unreasonably. And what that means is, if it might be reasonable to refuse if you wanted to wait 3 months to fly your uncle in from England or something. But, you know, if you've got want to delay the meeting for a week so your support person can come, that's probably reasonable. So they can't unreasonably refuse. If the dismissal was performance related, were you given the opportunity to improve your performance? And the Fair Work Commission also, again, has very broad powers, any other factors it considers relevant. So those factors might be your age. So if you're 65 and you might never get a job again, that might be a factor, and you're planning to work until you're 70. Or it might go the other way. You're 65 and you're planning to retire at 65, then it might go against you. The length of your service. So if you were there 20 years and you got sacked for something really minor, they might look at that. Your ability to find employment after termination. And that's very relevant in these times because the unemployment figures have surged because there's no jobs at the moment. So that might be a factor. If you've got dependents, what assets you've got, what debts you've got, your literacy level. So lots of migrant workers who, you know, again, have the chances of getting work, again, is difficult. During this period of COVID, unfair dismissal claims increased by 60% in April compared to last year. That's because a lot of employers were unfairly standing people down, and they weren't, you know, no one knew what to do. So it wasn't that they were really bad employers. Some were. I'm doing some at the moment, some unfair dismissals, but there's just a lot of confusion. And the law changed so quickly, and it changed almost every day. Justice Ross, who's the president of the Fair Work Commission, said there's been a lot of, and the voluntary settlements of matters had declined. What that means is you go to the commission and you can conciliate and you can agree on an outcome. But he said that's declined, which means that people are more prepared to go forward and try and fight their case. Again, that's perhaps a reflection of the times where there's not much money around. Stand down disputes particularly around stand downs have, you know, doubled times 5. There were about 10 this same period last year, now there's 50. So there's a lot of disputes going on in the Fair Work Commission. So if you ring them and you can't get through, that's why. Now, I think redundancy is a little bit confusing at the moment because really once JobKeeper came in, there wasn't really a reason to make people redundant. You could give them JobKeeper. And a redundancy, if it's genuine, is a defence against unfair dismissal. So if you dismiss someone or you make them redundant, you can say that I did have a downturn in business. It gets confusing because this was before JobKeeper came in. There was a couple of cases where they just sacked people and made them redundant. In this case here, Auscript. But once JobKeeper came in, then there was probably no basis to make people redundant. Does that make sense to people? Sarah, does that make sense? So the position is no longer required to be done because of an operation. This is a standard test for redundancy. You've got a position that's no longer required to be done by anyone. It wouldn't be reasonable to redeploy employer elsewhere because maybe there's no other position anywhere, or they don't have the skills, and you've met the consultation requirements in the applicable modern award or enterprise agreement. That's what happened in that case, Auscript. They didn't consult, and they found that that there was an unfair dismissal, so it wasn't redundancies. And now it also suggests that because of JobKeeper, as an alternative to redundancy, it gives employees a better chance to fight claims against their employers. I've got one at the moment. This is the case I was talking about. They sought very early on to make 58 employees redundant, and it was held that they didn't properly consult, because again, the award or enterprise agreement always has a consultation provision. The consultation they did was hollow. They'd already made their decision to make them redundant. They didn't treat workers with dignity and respect as what was held. And employees had offered to stand down, they'd offered to use their own leave, they'd offered to go leave without pay or take career breaks. They had actually come to the party and said, don't make us redundant, we'll just stand down without pay for a period of time. And the employers still went ahead and sacked them or made them redundant. And that was found to be a very harsh, one of the early decisions. So, as I've said here, you've got to, I think I've repeated that, the consultation requirements and entitlements. You've got to consult, and you've got to consider the availability of JobKeeper. Let's look at working from home. This is when an employer is requiring attendance at work. If you are, and I've done a few of these cases recently as well, where the employer is saying, you're getting JobKeeper, we now need you to come to work and do a few hours. And there's been a lot of argy-bargy about that. Some people just want to stay home and get JobKeeper and not ever go to work again, which sounds very nice to me, but it's not really what JobKeeper's for. But this point is about if you've got responsibility, like, you know, you're a carer or you're a parent, you know, particularly during homeschooling, then you had a right to request flexible work arrangements around that. People with disabilities, people 55 or older, people experience family and domestic violence, you had a right to request working from home or request changes to being required to attend the workplace. The employer, as you may know, is required to make reasonable adjustments for people with disabilities or to accommodate care responsibilities under the discrimination legislation. It may be lawful and reasonable to work from home, especially if it's done to comply with OH&S law. So if you've got someone at work who's had an outbreak of COVID, then obviously directing you to work from home would comply with your occupational health and safety obligations in the workplace, because you don't want everyone to get sick. JobKeeper directions, which I'll get to in a moment, may be that you work in a different location. So if someone has COVID at your main place of work, but there's another branch, you might be directed to go work at the other branch. But it also might include working from home. There's some issues around work cover insurance, but that's probably not relevant for you guys. Discrimination law is actually really interesting because unlike the Fair Work Act, which does have a discrimination component in there, this is for the adverse action where someone, you know, sacks you because you know, like you don't go to work because of your care responsibilities. You can take a claim under the Fair Work legislation. But the equal opportunity legislation is interesting because it actually imposes positive obligations on employers. You have to actually make reasonable adjustments for employees if they ask for them. So say, for example, you know, I'm having difficulty with my eyesight and I can't type. I might be able, or I've got RSI and I can't type. A reasonable adjustment might be for my employer to get me Dragon Speak or some sort of speaking technology that I can actually, you know, dictate or speak. So it's a very powerful requirement on employers. I've got someone at the moment who's off work sick, and the employer sends a letter saying they're going to send her off to get a medical, and if she fails it, they're going to sack her. And so I've written back and said, well, have you heard about reasonable adjustments? I mean, it's not just as simple as to sack her. They've got to consider what they can do to help her get back to the workplace. These reasonable adjustments, I've written here, soften the effect of the inherent requirements defence, because if someone can't do their job and they can't go to work, the employer can say they can't do the inherent requirements of their job and we're going to sack them. Then the defence to that is you have to make reasonable adjustments to allow me to do the inherent requirements of my job. And that's an onus on you. And if you don't, then I can take action against you. So these new sections of the Fair Work Act, you would have heard that there's new provisions in the Fair Work Act. The JobKeeper amendments operate subject to anti-discrimination law. So what that means is anti-discrimination law trumps it. You know, they operate to the effect that they don't take away your rights under anti-discrimination law, as well as adverse action and unfair dismissal. So there's been a lot of changes since COVID-19. You would have seen them all. Some awards actually changed. There's the introduction of a pandemic leave. If you heard of the pandemic leave, you can get 2 weeks unpaid leave or half annual leave rate. The JobKeeper allowance is changing daily. I wrote this a few weeks ago or a month ago, so it's probably not changing as much now. But except that they had a $60 billion, they underestimated or overestimated by $60 or $70 billion, which was quite funny. You must be an eligible employer, and our website's got more information on that. And so far, and Morrison's kept very firm on this, it excludes short-term casuals, and it excludes holiday visa workers, which annoys me because I have a holiday visa worker who's working for me at the moment. There's also been changes to the Fair Work Act itself, which, and that was the easier way to do it. If we look at our pyramid again, the Fair Work Act is the underlying, and all modern awards are referenced, and enterprise agreements are referenced down to that legislation. So to try and change all the awards, which is what they started to do, the clerks, restaurants, hospitalities awards, it was taking too long. There's 121 modern awards. By the time they change them all, the pandemic will be over. So the decision was made to change the legislation, then that would flow up and change the awards where required. Initially, the ACTU opposed it really strongly, Sally McManus, but in the end, they came to an unhappy marriage or a happy sort of divorce, and the union and the government came to an agreement. And one of the key agreements was that the changes that were put in place would have a sunset clause, which means they'd only be in place for 6 months or so, and they expire in September sometime. The other thing that's changed, the key things that have changed, sorry, but things going on here, is that the changes that came in more detail. Firstly, there was something called a JobKeeper enabling direction, and what you must, and you can give your employees directives, they call them. So to give a directive, your employer must be someone who qualifies for the JobKeeper scheme. You can't be giving JobKeeper directives if you are not an eligible employer. And what that means is you're entitled to JobKeeper payments for your employee in order to give them directives. So what are the directives? A JobKeeper enabling directive stand down. This is a flexible stand down and allows you to reduce or change the hours and working patterns of your employees. Prior to these directives coming in, you couldn't do that. Either you were stood down or you weren't stood down. Now they've softened that and said that you can reduce hours, change working patterns. You can direct your employees, or you can be directed as employees to perform other duties. It's got to be within your skill set, but they're very broad with that. And it's got to be within the scope of an employee's business. Very early on, my sister runs a cafe, and she asked me, can I get the my staff, because of course she had big restrictions, she cleaned my house for me. And I said, probably not, because your house isn't the business, but she probably could have gotten to clean the business, but maybe not her own personal house. Or maybe she could have. I mean, maybe if they challenged it, you know, the commission would make a decision. And you can direct an employee to work at another location. Conditions apply. So the directive must be reasonable. The employer must genuinely consult with you. You just can't walk in one day and say, bang, you know, you've got to do this. The employer must give you written notice 3 days prior that this is going to happen. So they've got to consult, then they've got to confirm it with written notice. There's some exceptions to that. If you both agree happily, then you don't have to have the written notice. And the directive must be safe. So they can't require you to come to work if someone's got COVID-19 in the workplace. Do you know what I mean? So it's got to be a safe directive. The employer can also make requests of you. So it can ask you to work different days and times, but no reduction in hours. So it can do that. It can shift you around a bit. It can ask you to take annual leave at full or half pay. And there's a case that happened, I think 2 weeks ago now, where it was first decision under that, which I'll talk about. The employee must, the employee can ask, and they can also, the employer can make requests, the employee can make requests. So the employee can say, well, if you stand me down, can I work at another employer? And because I had a friend who's a lawyer, family lawyer, and her boss was going to stand her down. The only thing she's ever done is be a lawyer, and she was going to stand her down before JobKeeper without pay. And she was refusing, or she was saying she was going to refuse to allow her to work anywhere else. And my friend was going, what am I supposed to do? Sack shells at Aldi? I mean, the only skill I've got is being a lawyer. It didn't come to pass, but it's got to be, they've got to reasonably consider it as well. Just like the employee has to reasonably consider the employer's request, the employee has to reasonably the employer needs to reasonably consider. And during stand down, you can ask, can you do training or professional development? And once again, they've got to reasonably consider that. The Fair Work Commission, as I mentioned, has got a new jurisdiction, and that is handling disputes before it and about JobKeeper. So if you believe that your employer has not complied with its consultation obligations, or it's trying to get you to do work that's not in your skill set or not in the employer's business, you can raise a dispute. But the whole thing about business is very flexible. So the case they give in the examples is a woman who works in an office, but the business is some sort of manufacturing or distribution place. And this woman, for whatever reason, whatever random reasons, has a forklift driving license. So there was no work in the office, but there was work in the warehouse. So they actually asked her, would she work in the warehouse? And she said yes, because it was in her skill set. And so she went off and started driving forklifts for a while the pandemic's on. So the first step is an application from an employer or employee or their representative. The Fair Work Commission can make any orders which it considers desirable to give effect to a direction. It can set aside a direction, or it can substitute a new direction if it doesn't think the direction was reasonable. And it can give any other orders it considers appropriate, taking into consideration fairness between the parties. So it's, again, very broad powers. So what sort of disputes? So the questions that will be asked, or has to be answered, is the directive because of the pandemic? It can't be just because of a random reason that they just wanted you to suddenly drive forklifts. Can you be usefully employed elsewhere? Are the alternative duties within your skill set? Is the alternative workplace suitable? And the reasonableness of your refusal to refuse the directive, to work different days or times, or to take annual leave. Was the directive given unreasonable in all circumstances? Did the employer comply with consultation and notice? Was the directive necessary to continue the employment of one or more of the employees? Was it necessary to allow the employer to continue? Have there been any disputes? Well, yes, as I said, there's been a few. This one's an interesting one because it went against the employee. She was a part-time employee and she was receiving double her usual wage with JobKeeper. Maybe that annoyed the commissioner, I don't know. But the employer requested her to use 1 day of her annual leave per week over 16 weeks to reduce the employer's liability. So if an employer is carrying 6 months of annual leave and you leave, they've got to pay you that. So they're keen always to try and keep the liability of annual leave down. She refused. She didn't want to do that. The dispute was handed to the Fair Work Commission under its new powers. So the finding was that she was ordered not to continue to refuse the request. She lost. The commissioner found that the request was reasonable in all the circumstances. So that's a bit of a surprise to me, to be honest, but that was the decision. So I suppose it shows me, or it suggests to me, that the Commission is not favouring employers, but, trying to keep, everyone is trying to keep employers in business. Do you know what I mean? So to me, that seemed like a fairly employer-oriented decision. But I suppose in these circumstances, you can understand how that might be the case. Does anyone have any questions? Sarah, no? You listened attentively, no questions? Let me see if anyone's written anything. No one's written anything? No one's got any questions. Was it useful? Recommend your friends to come next time. I've only had half a dozen or so people, and I really want this to, my goal as part of what I love to do is, I think young people in particular don't know what their workplace rights are, is to educate and inform so that people know what their workplace rights are out there. So we'll be running these probably once a month. I'm going to do these. and we'll put it on Facebook, share it with your friends, send it out, try and get people to join, because I think the more knowledge is power in the workplace. If you know what your rights are, you know that what you can resist and what you can't resist. Okay, lovely to see you. We'll put this up on Facebook as a recording. And again, feel free to share it amongst your friends. See you next time. Bye.